All right, this court hearing has been weird thus far, and it was actually a little bit saucier than normal. We sort of get to see what some of the litigation styles of the attorneys will be. And by the end of it, Thompson is looking redder than a beet.
Was stalking the victims ahead of time, and at least 12 prior occasions prior to November 13th, his phone was in the area of the residence. All of these occasions, except for one, occurred in the late evening and early morning hours. For me, that signals premeditation and planning, and why he's being charged with first-degree murder.
Now, this is not the first time that people have been accused of leaking facts of the case. And in fact, prosecution has been under fire at least 2 times before, and I feel like this has been under discussed.
Battle between the attorney representing the Gonsalves family, Shannon Gray, and the judge. According to documents, Gray doesn't believe he should have to follow the gag order, and he accused the Latah County prosecutor, Bill Thompson, of leaking information about the case to the media. And Gray is still fighting for himself and his clients to be allowed to speak freely about the case.
This article that actually identified Othram Labs as the private lab that at that time the state prosecution had refused to name. So defense attorneys were attempting to figure out and identify who this third-party lab that the state used was, and an article at the time came out, and defense attorneys actually said that the reporter that was recording this information knew more or had more disclosed to them about the case than actual defense attorneys had at the time. Verbatim, it says, "I'm aware of a specific news report in this case regarding Mr. Kohberger's DNA as published by the New York Times on June 11th, 2023, that, quote, FBI personnel worked with the profile that Othram had produced, spending days building out a family tree that began with distant relatives," end quote. The motion goes on to say the New York Times sources have more information than the state has disclosed to defense. This New York Times article generated intense media coverage and interest, the scope of which is explained in the True Scope report attached as Exhibit D. This is from the declaration of Ann C. Taylor in support of defendant's third motion to compel discovery.
Is collecting the media coverage. Is really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it, and it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be. For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that.
So duh, everyone knows there's lots of misinformation out here. If I had $1 for every time someone said, "But Neeks, what about his sister who turned him into the police or said that she was suspicious of him? What about him cleaning out his car? What about allegedly what he was doing when the police arrested him?" I mean, so many prejudicial, unverifiable alleged facts have been leaked in this case. But even more prejudicial than that, we know that people who have been accused of crimes before, even if they are unrelated to the crime that they're later accused of, and this means if they're charged with a crime and never even convicted, it's still prejudicial for a jury to know that. And we know that it's been widely publicized that allegedly Bryan is this ex-addict and this ex-thief, and there were all these charges that his dad filed, but allegedly these charges have all been sealed. We have no idea what they are, and nor do any of the reporters who are reporting on the alleged crime, unless it was leaked to them by law enforcement, because how the hell else would they know if it's a sealed file? Prejudicial as hell for that to be, what jurors are going in the courtroom thinking about Bryan, whether it's true or not, whether that conviction was thrown out because there was no proof. And there was just, oh, shock air, a lying cop or whatever it may have been. The case was dropped because it was BS, or the case was dropped because of a diversion, or whatever it may be. It doesn't matter. It's prejudicial to Bryan.
I'm looking for references to prior records. Maybe they're victim impact statements where people, victims' families may be suggesting what the outcome should be. That could be prejudicial.
The worst part, obviously, is being in the same room with him. I know what he has done. It makes me sick that he sits there in his suit and he sits there and taps his hands and you're just sitting there and he, sits there and rocks back and forth in the chair. And I'm thinking, why is he sitting in a big old judge chair and all dressed up in a fresh haircut? And I've looked it up, never seen another murderer or whatever he is convicted up to this point of a case, not in handcuffs, not in shackles, one or the other or both, and in orange. Like, I want to see this guy die.
How did the community respond, or their candlelight vigils? GoFundMe efforts going on, the status of the victims and focusing on that. So there's a gambit. Political elements that are important in high profile cases, because it might be that a politician's involved. So it just depends on the case.
In favor of House Bill 222. House Bill 222 has passed the House.
In the wake of the murders of 4 University of Idaho students, House lawmakers voted today to give the university an extra $1 million. This money would go to the U of I for unexpected expenses and increase security on campus following those murders.
Attorneys for Kohberger finally claimed that they not only wholly believe in his innocence, but they also stated, it was a privilege working for him. Everyone discussed how Anne put her hand on Kohberger's shoulder, and everyone was up in a shitstorm about it and saying, either it does mean something or it doesn't mean something. And it's like, here again with this case, I get a sense of deja vu. Because guess what? Another reporter was actually up in arms about the fact that the first attorney for Kohberger in Pennsylvania, who represented him during his extradition case, made a statement. Check it out.
He had said to me that he believed that he would be exonerated, which I believed implicitly that he was innocent of the crimes.
Now that is we're both lawyers. You're just a better one.
I don't know about that.
I do. Your zealous representation responsibility is to do everything you can to advance his cause under law. That's zealous representation. You do not have to say you believe he is innocent. You can say he's not guilty of the charges, they can't make the case, I think that they're speaking out of school, I don't think they have what they think. There's a whole range of qualifying statements. But innocent is something else. Innocent is that you believe he did not do this. Do I have it accurate?
Well, I don't want to put those words in my mouth. He said he was eager to be exonerated, which I believed him to mean that he believed he was innocent. I wasn't judging the case at that point in time. I didn't have the affidavit of probable cause. I knew none of the facts, and I didn't ask Bryan about any of the facts or circumstances surrounding the case either.
Okay, that is very important, and I apologize because I have been slapping you around for making such a heady assessment so early in the case. But now that we put out the statement and you're saying, no, this is what he told you, and that was your takeaway about how he felt about his own situation. Very different. I apologize for any other inference. I'm glad we cleared it up.
I will end by saying this. Our defense team firmly, and I mean firmly, believes in Mr. Kohberger's innocence. And right now, he's being held to have a trial in a county that believes that he is guilty. In this country, we pride ourselves on a jury system that doesn't stand for that. In this moment, I see that you have two choices. You can let us continue and do comparative surveys as planned, or you can maintain the stay. And at the venue motion, you will hear that the data for Latah County shows a presumption of prejudice, but you will not have comparative surveys to fully inform the court. As you consider this, there is absolutely nothing that gets risked if you change venue. But if you deny a change of venue, Mr. Kohberger's constitutional right to a fair trial is denied. There's only one human being in this case with the right to a fair trial. It's Mr. Kohberger's and his alone. There's no legal right of this community jury pool for trying to do voir dire in a death penalty case. But if you look at the population as a whole, what the U.S. Census says about Latah, that keeps getting expressed in this courtroom. The questions asked, the topics, the order, the open-ended, the specifics, they were all done using information that is out there for everyone to see.
I'm going to say it like this. Mr. Kohberger's my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias.
So we start out with this weird position that Thompson is in to begin with, which is him saying that, hey, the defense is fine. They can totally do a survey, but it can't have these questions that are misleading. Now, he calls these facts as though the defense has inserted facts in, but they're being misclassified as facts because they're technically not facts and they're being asked in the question form. Have you read, seen, or heard? Insert example question here. Thompson finally gets checked for this misclassification, and defense actually went as far as to argue that they had been wrongly accused, that they're arguing for hearings that for the first time has become a part of their litigation experience. In other words, they've never experienced, as Ann put it, having to fight to have a hearing over something they're already disagreeing about. They can't even get to the hearing part without feeling like they get to the crux of the actual problem that's brought the hearing in the first place, right? And you could kind of see why she gets to feeling this way. At one point, she even actually points out, it's been, 20 minutes and our expert has still not been able to testify yet. It got pretty heated. Now, what is a weird, as defense attorneys put it, oxymoronic argument that I believe the prosecution is making here is he makes a big deal out of these 400 people who have supposedly been poisoned or tainted as the prospective jury pool because they've merely been asked a question. Now, defense points out several reasons why this doesn't make sense, as well as it being oxymoronic. It doesn't make sense that he would complain about these 400 people supposedly being tainted, yet they have a big hearing and now thousands on thousands of people are paying attention to the issue versus the 400 tiny percentage of Latah County that would have been poisoned in the first place.
Your Honor?
Yes.
At this rate, we may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process?
Well, there's no question I'm going to let him testify. I just wondered about what's in this. I haven't even looked at this, but it's you're comfortable having this come out into the public?
Yes. After last week's hearing, absolutely.
Okay, and you looked at it, Mr. Thompson?
We have concerns, Judge.
Is it alarming?
Well,
Does that non-dissemination order change how you did your work?
I'm sorry, can you
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you use contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
good afternoon, folks. My name's Bill Thompson. I'm the Latah County prosecutor. And it's sad to be here, but happy to be here at the same time.
You turn it up.
I can't hear.
Kohberger.
Well, I'm going to do my best to turn this up.
Yeah, you don't have to.
If I put the microphone up, is that better?
So yeah, but you don't have to type things that are recorded here.
And let me preface, there is a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all of the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can.
In that clip, you heard reference to the probable cause affidavit.
Yes.
And did you hear reference to sharing it with all your readers and watchers?
Readers, watchers, and listeners, and anyone else who's interested.
Did your research tell you that the media took Mr. Thompson up on that offer to share this far and wide?
Yes.
Good afternoon, folks.
What did you see?
Basically, the media took that document and then published the highlights and key findings in that document and added editorial commentary to that information.
I think it's all just been ridiculous. I mean, we could have, ended the whole position of the argument on the fact that the Supreme Court for Idaho states that defense attorneys don't just have to bring that there's been a lot of coverage, but it explicitly talks about coverage that was untrue. And how else would you assess if this population has been affected by said coverage? At the last hearing, prosecution totally admitted, we could totally just X out those jurors during the jury questionnaire process. And so everyone's like, problem solved. Now, I know I normally bias fully disclose, lean towards defense's side of the argument. But, this goes for defense and prosecution. On both sides, we do have the problem of jurors lying because jurors will lie to get themselves on the case. OJ famously had this play out during his famous case before American Eyes in the courtroom, right? Juror after juror after juror bites the dust and is replaced because many of them were found to be lying in their questionnaires. And this often happens. So, you know, it's not always as easy as saying, okay, so you X those jurors out, case closed. But again, I'm totally on defense's side here because it's just absurd that this is the problems that they're bringing. And the big fact that everybody really seemed to miss here, and I swear it seems like the judge is just like playing dumb or something. Like he really honestly sort of acted like he couldn't wrap his mind around this particular issue. That these stalking allegations are coming straight from the probable cause affidavit in this case. That's to state that that is not a part of the public record or is, you know, not a part of the public purview is kind of absurd. Simply absurd. It's not even necessarily an unfair statement if you take the PCA for its word. So if you believe all of the law enforcement officers who completed that PCA, stating that he stalked the victims beforehand, if we're someone who were to be someone who was actually capable of being convinced by those previous phone location data that the probable cause affidavit alleges that it has, you know, stalking isn't the most outrageous word to take from that. And that's exactly what the news did. It's not just a lie. It's literally the headline that almost every media source that reported on the crime turned. That came straight from the PCA.
Information that now he's calling facts. You know, he's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information that the way that the state and state actors put information into the public record that has now been disseminated. And we have not violated that order. And I do resent being accused of that.
I appreciate that. I mean, those two questions were not in the public record. They weren't. I mean, they came out, but that was not the court, I mean, where it came from. It just came out of the media or somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client. So, I mean, here we are. I mean,